This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today, we talk about a disbarred criminal lawyer who was unable to fool a bankruptcy court, and why the bankruptcy court ruled against the lawyer-felon over title to real property. Because even a bankruptcy court can note that a felon, like a tiger, can never change his stripes. The litigation in the US Bankruptcy Court involved a dispute over the ownership of property located in Watermill, New York. The plaintiffs claimed that a 2015 deed transferring the property to the debtor was fraudulent and seek to have it declared void. The defendants argued that the plaintiffs' claims were barred under various legal theories, including judicial estoppel, res judicata, laches, unclean hands, and adverse possession. In a case entitled RJT Food Restaurant LLC Debtors 2027 Deerfield Limited and George Guldi Family Trust versus RJT Food and Restaurant LLC et al., the United States Bankruptcy Court for the Eastern District of New York on April 4, 2025, found that the plaintiff's claims were barred by judicial estoppel and res judicata, but denied summary judgment based on tax estoppel, equitable estoppel, laches, unclean hands, adverse possession, and ratification of the 2015 deed. The reasons for its findings, of course, start with George Guldi's criminal history. On March 25, 2009, Guldi was indicted for a mortgage fraud scheme, insurance fraud, and other crimes, and pled guilty in 2009 to the mortgage fraud case, and after a trial was convicted in 2009 on the insurance fraud case. Guldi was sentenced to a prison term of 3 to 6 years for grand larceny and 1 to 3 years for insurance fraud. Guldi remained incarcerated from February of 2011 until July of 2017, when his conviction in the 2009 insurance fraud case was overturned on appeal based on finding of reversible error resulting from the trial court's denial of Guldi's challenge to one of the jurors. In 2019, Guldi was indicted again, this time by the United States Attorney's Office for the Southern District of New York for offenses committed during his prior incarceration. Guldi was convicted of wire and bank fraud in the 2019 bank fraud case. In August of 2023, he was sentenced to 3 years in prison and directed to pay $358,556 in restitution, and was reincarcerated in March of 2024 and is currently in prison serving his sentence. The trustee moved for summary judgment, arguing that plaintiff's claims should be dismissed based on judicial estoppel, tax estoppel, equitable estoppel, res judicata, and laches. The trustee also sought summary judgment on his second counterclaim for adverse possession. The defendants argued that the plaintiffs, including Mr. Guldi, should be judicially estopped from asserting any interest in the property in the case because Guldi, in connection with his criminal matters, repeatedly failed to disclose any interest in, direct or indirect, or any claim to the property and or any income generated by the property. Judicial estoppel generally requires that the party to be estopped and the party who took an inconsistent position in a prior proceeding is the same. Having determined that the judicial estoppel is applicable to the facts of this case, the court found that the necessary elements of that doctrine had been satisfied. As a result, the court granted the defendant's motion for summary judgment in part and dismissed plaintiff's claims for declaratory judgment and quiet title with prejudice. The plaintiff's cross-motion for summary judgment was also denied. Although for purposes of summary judgment the court resolved ambiguities and factual inferences in favor of the plaintiffs, the court found it beyond reason that Guldi, a businessman and former lawyer with experience in real estate matters and also a person with severe financial troubles, could be unaware of the 2015 deed, the quiet title action, or any of Bivona and other defendants' action with respect to the property, a house in Watermill, New York, worth over $3 million. The tangled web created by Guldi to, in the court's view, hide assets from creditors was in part predicated on the assumption that Bivona and other parties would be trusted to fulfill their role in the plan. In the end, this appears to have been Guldi's fatal mistake, and his attempts while in prison failed. In my opinion, Mr. Guldi proved that a lawyer, although knowledgeable on the law, makes an incompetent fraudster and explains why he is still imprisoned. His claim to title to the real property was barred by judicial estoppel and res judicata. The property stayed in the bankruptcy estate, and Guldi's latest attempt at fraud from his prison cell failed. This video was adapted from my blog, Zelma on Insurance, which is available free to anyone who clicks on the URL zelma.com/blog. You can subscribe to the blog, and if you do, you'll receive notice of every blog posting, usually 5, sometimes 6 a week, and you'll also gain access to the more than 5,000 blog postings. Please tell your friends and colleagues about this blog and the videos so that they too can subscribe. They're free. And if you're interested in further detail about insurance, insurance claims, insurance law, and insurance fraud, please consider for a very small fee subscribing to my Substack publication. Thank you for your attention.